Hi, I'm Mark Cunningham with Grace Property Management. If you're a landlord in Colorado, this is big. We have just seen 4 significant new laws get passed by our legislature that are impacting property owners and landlords effective immediately. So I'm going to give you a brief overview of those 4 laws to ensure that you are compliant with new laws that our legislature passed. Number 1 relates to application fees. Now, by the way, these laws apply to all landlords across the board. So they don't just apply to us because we're a property management company. If you are a landlord and you own one condo, one single family home, and you rent that out, these rules apply to you across the board. So the size of your company, the size of your portfolio doesn't matter as it relates to these, with a few caveats specifically. But number 1 relates to application fees. And here's just a couple pieces of the new law as it relates to application fee. Number 1, it limits the amount that can be charged. It requires disclosure of what those fees are, and it requires a receipt for applications. You say, well, that's all fine stuff, and yeah, it is. It also requires specific action when applications are denied. So you can't just say, oh, sorry, you're denied. You have to follow up and give them certain types of disclosures after that. It requires that you also refund any unused portion of the application fees. That gets a little bit sticky. It also limits the information that you can consider when processing a rental application. Now this is big, this is important, because specifically you may not take into consideration rental or credit history beyond 7 years prior. You no longer may do that legally. You also may not take into consideration criminal history beyond 5 years ago, with some exceptions. That means the criminal history that your applicants potentially did, if it was more than 5 years ago, again with some specific exclusions, you cannot take that into consideration. That's a big change in our rulings and our laws. We have to be aware of this. Now by and large, this new ruling on application fees and processing the application doesn't seem to be a huge major impact for our industry, but you've got to make sure you're in compliance. The second law relates to bed bugs, and specifically it has a couple things that say this. If you as the property manager or the landlord or the property owner are notified by your tenant that they think there may be bed bugs, you now have 96 hours, the clock starts ticking, to find a qualified inspector, it must be a qualified inspector, to get in there and inspect the property. You have to report legally those findings from the inspector to the tenant, and then if they determine that there are bed bugs present, you must treat to eradicate at your expense. Doesn't matter where they came from, none of that matters. Your expense as the landlord. So this is a change in the way this is handled. Now, does this impact landlords? I don't think this is a hugely negatively impacting law for landlords. I think some of these laws are very fair to tenants. Number 3, warranty of habitability. Now, Colorado already has a warranty of habitability law, but this new law extends the current warranty of habitability, greatly expands the tenant's rights within this warranty of habitability. Warranty of habitability really means that we as landlords are required to provide a habitable property to a tenant. It has to have running water, has to have heat, has to have things you would think of. This new rule, though, expands what those requirements are and greatly reduces the amount of leverage a property manager has in fixing things that may be questionable on how quickly you can get them fixed. So for example, you are required now to give a specific response from landlords in specific time frames. The clock starts ticking once a notification comes in from a tenant if they suspect something is broken or needs repaired on a habitability issue. It allows the tenant to withhold their rent. They can legally withhold their rent payment and not pay it if this is a habitability issue, and this is a very complex rule, so we're not going to get into the fine details of it, but it allows the tenant to potentially withhold their rent. It greatly expands landlords' potential liability for retaliation, meaning if you're mad at your tenant because you think they're demanding too much, you cannot retaliate in specific ways. When tenant does give notice, so for example, let's say the tenant calls our office and says, hey, I think I've got mold. That's going to fall underneath this umbrella of habitability. The new law requires some things like this. We must respond within 24 hours. Now, that's a little bit tricky because what if they send an email at 12 o'clock midnight on Friday night? Doesn't matter. Get 24 hours to respond to that request for the habitability issue. Secondly, the response must indicate our intent, the landlord's intent for remedying their condition. So what are we going to do about it? You have to tell them that within 24 hours. Third, we've got to provide an estimate of when the remediation will begin. That's hard to do because we don't know our vendor schedule yet. So repair request comes in, we've got 24 hours to notify the tenant of what we're going to do, and we've got that same time frame, we have to let them know when the remediation work will begin. And then it gets worse because we also have to provide an estimate of when the remediation will be completed. We don't even know what's going on yet. Tenant calls and says, I think I have mold. Well, that may be just the cleaning of a wall that repairs it, or it may mean we have to go in and remediate the whole house. But within 24 hours of their contact with us, we have to give them an estimation of how long it's going to take us to fix the problem. That's a pretty unreasonable thing, but we've got to do it. That's the new law. Now, there's a lot more difficulty within this law, but again, keep in mind, whether you like it or not, you are required to abide by it per new Colorado state law. The fourth new rule that just went that just passed is the 10-day cure law. So you may have heard this concept in the past about a 3-day notice. Right? A tenant doesn't pay their rent. The landlord has been required to post what's typically called a 3-day demand notice, meaning, hey tenant, you've got 3 days to pay the rent that is now outstanding. Otherwise, I as the landlord, potentially, I could start a legal eviction process. Well, no longer is that 3-day notice period in place. That has now changed to a 10-day notice, a 10-day notice form. Now, there are a few caveats with this. For example, if you have a single family home, if you're an owner and you own a single family home and you don't own too many properties, then you don't need to give them a 10-day notice. It can just be a 5-day notice. But if it's a condo or a townhome, it's got to be 10-day notice. And if you own more than a certain number, it's got to be a 10-day notice. Again, it gets very complex. So just think in terms of the 3-day notice now goes to a 10-day notice. And this includes rent demand. So if the tenant doesn't pay their rent, they've got their grace period, whatever the lease says, but now they've also got 10 days, an additional 10 days to pay before you can initiate legal proceedings for an eviction. It also includes demand for compliance for non-monetary violations. So if the tenant has broken a term of their lease, they want to do something, you're trying to evict that tenant, you need to give them a 10-day demand notice to fix the problem first. It also includes notice to quit for repeat violations. Now, what our attorney has told us is with this new 10-day requirement, the soonest, the absolute soonest, they would be able to get a court date for non-payment of rent would be the 22nd day of the month. That means if your rent is due on the 1st, the tenant doesn't pay, so you get out there immediately and you post that 10-day demand notice, you wait for the 10 days to hit, we send that 10-day off to our attorney, the attorney takes it, the attorney gets a court date. The absolute soonest they would be able to get into a court for a non-payment of rent will be the 22nd day of the month. This is going to expand the time frame it takes to potentially evict a tenant who doesn't pay their rent, probably up to about 60 days total. In the past, it's always been as tight as 30 days. It's been expanded out to 60 days. Now, is this good for tenants? Yes and no. It's good in that tenants have a longer time frame to pay. However, our personal view is it's not good for tenants, and here's why. When a tenant would come into us and they would say, hey, I don't have all my rent, I can't pay all my rent, we would allow them to make a partial payment. We'd say, okay, well, can you pay half? Yes, I can pay half. Okay, great, pay half. We're going to give you a 3-day demand notice, but we're not going to process the notice. We're going to post it on your property. You've got 3 days. Now, we'll hold the notice. We'll sit on the notice, and as long as you come in with the other half of the rent by, let's say, the 7th day, the 8th day, then we're good. We won't process the notice. Well, now because of this, because we can't do that anymore, now if we take a partial payment, we've got to reset the clock to another 10 days. So this greatly reduces the flexibility that a landlord could potentially have to work with a tenant. That's why I think this really hurts tenants. We want to work with tenants. We do work with tenants. Our eviction rate on an annual basis is less than 1%. Less than 1%. Why? Because if a tenant can't pay rent, we want to work with them. This kind of handcuffs us. That's the way we look at this. This allows us not to be able to say, okay, great, we'll take a partial payment and you pay the balance here and we won't process it. Now we've got to say, you know what? You've got to pay that full amount. Why? Because it's a 10-day period. We've got to sit there for 10 days waiting for rent to come in. So I really think, although it's well-intentioned, well-meaning, my fear is this is actually going to hurt tenants. It's going to increase the eviction rate. I really believe that will happen, which is unfortunate. So regardless of your views on these laws, these things do greatly expand tenants' rights in Colorado. That's what the legislature came in to say they were going to do, and they've done that. Now, if you're a client of ours, don't worry. Hopefully this isn't scary. We've got all this under control. We make sure that we operate under the confines of these laws and all the other laws that are impacting landlords. If you're not a client of ours, then talk to your PM company. Make sure they're aware of these things. They're doing these things to protect you, to protect themselves. And again, it doesn't matter if you have a property management company or if you are self-managing your properties, these things still fully apply. So check these laws out. It's gonna shake up our industry a little bit. It absolutely will, but that's fine. We need to make sure that we're operating under the confines of the law. We do that for all of our current tenants, and we'll continue to do so.